Welcome. This is another video in the Legal Research Fundamentals series. It will introduce you to the concept of headnotes. I'll start, though, with some history. In the 1800s, John West, the founder of Westlaw, created a series of books called case reporters. These books still exist today. They're compilations of judicial opinions. In other words, they report judicial opinions or cases, hence the terminology case reporters. Of necessity, just due to the printing process, case reporters present judicial opinions in chronological order. That means you might have a contracts case followed by a torts case followed by a property case. John West recognized this chronologically based organization as a problem. What attorneys needed to make their research more effective was the ability to find cases by topic, not by date. So West and his team came up with a list of categories and assigned each category something they called a key number. As cases were decided, they gave each case one or more numbers, identifying what category, what area of law the case involved. This whole system of attaching topics to cases is known as the West key number system, and it's a crucial component of legal research. So what are headnotes? When a case is decided, the editors at West read it and give it key numbers based on every single area of law the case touches upon. Then they write a short summary of what the case says about that particular area of law. These summaries are called headnotes, and they appear at the top of every case. Each one has a key number identifying what area of law it implicates. Here are some examples. This is an on-screen case in Westlaw. It's called Castle Rock Entertainment v. Carroll Publishing Group. If you look underneath the caption and underneath the synopsis, you'll see the headnotes. This case has 22 headnotes, but don't worry, this is a lot. Most cases will have less. Now, look at headnote 1. It has a title which tells us into which of West's categories the headnote falls. Here, it's federal civil procedure. The synopsis under the title tells us what this case has to say about this area of law. This case is talking about some concepts that may already be familiar to you, or soon will be, from your Civ Pro class. On the right side, you see the key numbers. Remember how John West assigned every area of law a number? These are those numbers. We'll talk more about this later, but these concepts are organized from general to specific. So federal civil procedure is 170A, and as we go down into the subtopics, you will see different numbers, all beginning with 170A though, because they all relate to that main topic. So the topic summary judgment is identified by this unique number. Now, let's scroll down through these 22 headnotes. See how the titles change? We started with headnotes related to federal civil procedure and federal courts, but there are other headnotes too. In this case, they happen to all be related to copyright, but in other cases you might have headnotes about federal civil procedure, federal courts, copyright, contracts, trademarks, all of the diverse issues that came up in that particular case. The big picture on headnotes is that they're a tool that allows us lawyers to skim a case without reading the whole thing. We can read the headnotes for a quick overview of what the case said about a particular area of law. In fact, if you were looking at this case and you were interested in CivPro but not in copyright, you might just read the first 2 headnotes, skipping the other 20 headnotes because they all relate to copyright. With that, you have a basic understanding of headnotes, and I can't stress how important that understanding is. If you do any legal research when you graduate, you'll need to understand how to use headnotes. For litigators and trial attorneys, they will be a daily part of your work life, especially when you're first starting out. But even for transactional attorneys, if you do any legal research, you need to use and understand headnotes. Thanks, and see you next time.